Alright, how y'all doing today? Cheryllee back here with another video. Alright, how y'all doing today? Cheryllee back with another video. So I am Cheryllee back with another video. I am Cheryllee from the Everything Cheryllee brand. And sometimes I have to drink a little something, just a little apple juice. Cause my mouth gets a little dry when you're talking a whole lot. And I've been under the air conditioner for a few days, so nose a little stuffy. So if you hear me sniffing a little bit, it's because it's been so hot recently that you almost have to run your air conditioner every day. So a little apple juice, little Monica in the background, Mary J. Blige, Babyface, and let's see what else was in there. I think Wale. A lot of other artists. Brandy, she's in here too. Brandy, Eve. So I am Cheryllee from the Everything Cheryllee brand. You can find me on Instagram, everything_Cheryllee. Basically everything Cheryllee. Instagram, TikTok, YouTube, Facebook. I'm on Facebook too as well, but I want to change over to Everything Cheryllee over there too on Facebook. I don't be on Facebook that much. So I hope you all have been having a nice week so far. Today is Friday, July 30th, 2021. And just want to talk about a few things today from my constitutional law book. Constitutional law. So I don't know if you all know, but I did graduate from Strayer University right here in Washington, D.C. I have a bachelor's in business administration. I do have my master's in information systems. So let me talk a little bit about the things we studied in, I guess I would say in the program of information systems. Well, business administration was the degree that I did my bachelor's in business administration. So that was a pretty good program. It was a pretty good program, and I took a lot of courses like computer programming, business law. Computer programming, I took business law. Took I think a religious course, statistics course, accounting, managerial accounting, and I took a basic accounting course. But my business law course, I really did love that course. I learned a lot in business law. I remember one day we had to go to the board. A lot of times we were having, the professor would have us, read a couple chapters at home, and then when you come back, I want you to be able to explain some of these terms in the chapter. Terms like false imprisonment, menswear, active wear, terms like stuff like maybe like elements. What are the 6 elements in the contract? So offer, acceptance, consideration, mutual assent, legal capacity. So those are some of the elements to a contract. So you have to have all the elements for a contract to be legally enforceable. But I'm not talking about that today. I don't think I will, but who knows? By the end of the video, I might talk a little bit about contracts. But there's so many different types of contracts. So when you're doing a program, you don't really get deep down. If you get deep down into the subject files, that book, the book that you're using. But in other words, contracts, you're not going to study a whole lot of different areas of contracts, because there's so many different areas. So you might, in other words, your curriculum might call for one business law course, one accounting course, maybe two accounting courses, maybe one whatever your curriculum calls for. You might have one course that can just give you that foundation, and you could always take it further. Like I could have also went further in my accounting if I wanted to. So I took one basic accounting course, and then I took the curriculum called for managerial accounting and one basic accounting course. So I could have also went further and went on further with my accounting, but I chose not to. So I did my master's in information systems. But the business administration course, I did love that course, business administration, because I know I started out UDC, the University of the District of Columbia, right here in Washington, D.C. So I started out going there, and so I was studying office administration up there at UDC, the University of the District of Columbia, and my husband was like, no, at the time, I wasn't married, but he still told me, he said, honey, you shouldn't be doing office administration, you should be doing business administration. So I transferred from the University of the District of Columbia to Strayer University, and so that was like, when they had a campus downtown, they had a campus crosstown, downtown, Virginia, they had so many campuses. So he said, honey, you should be doing business administration, not office administration, because office administration is just, I guess I would say, an element or a section of business administration, because business administration is pretty broad. So business covers a whole lot of aspects of the business world. Running a business, I guess you would say operating a business, working in someone else's business, running your own, marketing, advertising, and promoting, and target markets, and marketing channels, total quality management. I probably dream about some of these terms, really. Continuous improvement, competitive advantages, comparative advantages. So it's a whole lot of terms that you run across when you're dealing with business. You want to be unique, marketing niche, and so those are some of the things. I learned some of the things we talked about in my business degree. But information systems, from what I learned, my major, my degree, I had a pretty good professor too there at Strayer University, right here in D.C., Washington, D.C. So what? Any company, more than likely, any company that you work for, any company that you own, you definitely going to have an information system, a system you have set up, to bring that, that vital information in. I would say to bring that vital information into your company, so you can make those decisions. Everybody needs an information system. Police departments, they need information systems. They need systems set up to bring information in. You have a business information system, accounting information system, all kind of information systems, depending on what type of company you're working for or you're running. You need an information system to bring. It's basically just a system that you have set up. You may have a system set up to do things this way. This other company may have their system set up to do things this way. Another company may have their system set up to bring that information in their company, because you can't make no vital decisions, important decisions about, what do you want to do in your company? What is your strategy? Or how you want to reach your strategy? How are you going to obtain your goals? How you want to obtain your goals? Reach your objectives and your goals. If you don't have a system set up, system is basically just how you want to do it. How am I going to do it? I do it. This is my system, and let me know how I'm gonna do this, how I'm gonna do that, how I'm gonna do that, am I gonna do that? I'm gonna do that using this system. I'm gonna do that using this system. I'm gonna do that using this system. So that's it. So what we had to do, I really love that course. I do miss Stray University, but I know one of my one of my friends around here where I live, she went to Stray University too. And she said, "Sure, I miss Stray University." I said, "Yeah, I miss it, but it ain't like I can live there." I mean, that is a point in time in my life. That was a point in time in my life that I had to move on from. It's like the balance sheet. When you're talking about accounting, the balance sheet, assets equals liabilities plus owner's equity. And it's a point in time. It's like a snapshot of how much your company is worth at that particular point in time. Or add all your assets up, your liabilities plus your owner's equity is supposed to equal on both sides. So in other words, your assets on the left equals liabilities plus your owner's equity. So your liabilities are the debts plus your owner's equity, and they're supposed to equal up to your assets on the left side. So basically, that is what, that's just my reasoning, how I, chose to explain that. But so let's I want to get into a few terms in my law book. So, as I was saying, this book right here is from, this is my constitutional law book. But I did take business law, where I learned about, I think it's a term in this book. First I want to start out with the term. It's not a term, I guess it's, I guess it is. I could call it a term, stare decisis. So stare decisis, let the decision stand. So in other words, back in the day, judges went down into towns and they solved those cases. Back in England, they solved the cases. So when they solved one particular case, they used their findings from that case to help solve future cases. So that's what they call stare decisis. Let the decision stand. So that is what they do nowadays too. They still do that. Looking at other previous cases to solve future cases. So stare decisis, let the decision stand. So that was one of the terms that I learned, in my business law course. And we talked about mens rea, actus rea. So mens rea, that's when you have the mental state to the fact. I guess I would say you in a mental. I guess mentally they're saying that you're thinking about committing a crime. So that's mens rea. Actually, it's on your mind, and you're thinking about, oh, I might want to go rob that store. So you're at that stage where you're thinking about it. But when you actually go do it, they call that actus rea. So actus rea. So basically, they probably can't get you for no. They can't charge you for no mens rea. But when you get to actus rea, then you acted out. You actually committed a crime. So we learned a whole lot. We learned about assault and battery. Different terms. Assault and battery. Assault. That's when you put a person in fear. If you put somebody in apprehensive and a fear, and they fear for their safety, that's what they call assault. Battery is when you actually hit somebody, but A lot of times that comes together. It comes together like, you know, they would say assault and battery, but you can still probably be charged with assault, simple assault, regular assault, simple assault. Um, so those are just a few of the terms. But let me get started with this book here. Just a few terms. Let me see what kind of music I can get on in the background. I always like to have some good music in the background. Okay. Okay, yeah, let's talk a little bit more about stay decisive. Alright, let me get okay, stay decisive. I hope they just flow with the music because I like to see when they go from one song to the next. Okay, stay decisive. American common law has developed by building upon itself. Courts continue to rely on private cases, as I was talking about. So they just solve one case. When they solve one case, they look at that case, and that's how they determine future cases. That's how they determine. I mean, that's not how they determine it, but I guess that's how they would look at previous cases to try to solve, you know, cases in the future. I guess I would say it that way. So it says while this doctrine has its roots in early English law, the court in Moore versus City of Albany set forth when the court has once laid down a principle of law that's applicable to a certain state of facts, it would adhere to that principle and apply it to all future cases. Future cases where facts are substantially the same. So in other words, if the facts are the same, they would apply it to a future case. A previous case, as I was saying, stand decisive. If the facts are the same, then they can apply that to future cases. So let me see what other term I have. Okay, let's talk about the Constitution. So what is the Constitution? We have the Constitution, the United States Constitution, that is the supreme law of the land. That's laws in the Constitution are laws that we all must follow. Constitution is a system of basic laws and principles that establish the nature, functions, and limits of government or other institutions. The American Constitution is youthful, which makes it all the more impressive. Consider other nations that rely on many more centuries, even thousands of years of tradition and law that has been fine-tuned to serve them. So law. And what is law? Law is a body of rules promulgated to support the norms of that society enforced through legal means, that is punishment. So the body of rules, that basically law. Rules and regulations, you know. Sometimes you can just put your own words in, long as they, you know, give that word similar meaning, the same meaning rather. So contributions from the past, compared to the series of events that have contributed to and led up to the drafting of the Constitution, American law is young, but its history cannot be ignored, as this is the base on which our law has been constructed. The earliest visitors to North America left their mark, which archaeologists study to better understand social and cultural development. So we have the Mayflower Compact. Mayflower Compact was a written agreement for self-government. It was signed, so it was a written agreement for self-government signed It was signed. I don't see the rest of, it just say it was signed. Oh, signed. It was signed in 1620. This document was a colonist first attempt at self-government. According to Gunderson 2003, the original compact has disappeared. However, a version of the compact is contained uh, in a Plymouth plantation written between 1630 and 1651 by William Bradford, second governor of the colony. So they always talk about the melting pot. It says the great melting pot. Representatives from every culture that has come to America, regardless of when they arrived or where they came from, share the historical development of our country and legal system. So our country and the legal system, the great melting pot. It is the common thread that binds all who have come here, the desire for something better. They come to America for a better life. That makes America law so unique and serving the pluralistic society that created it. Yep, but you do something wrong, they're going to show you how great they are. So that's how they go. The great melting pot. Everybody wanted, back in the day, they wanted to come here. They said they were searching for gold, and Christopher Columbus and Balboa and all them. They trying to, explore the world. They were trying to explore for a better life. Travel, see the world. Some say the world was round. Some say the world was flat. Some say the earth revolves around the sun. Some say the planets revolve around the earth. Just different views. So let's see what I have next. Okay, let's talk about the Second Continental Congress. 1775, the Second Continental Congress convened in Philadelphia. It's terrible up there now in Philadelphia. There's a lot of crime up there in Philadelphia. So every time I turn my TV on, something happened in Philadelphia. But this is the Second Continental Congress. The Second Continental Congress established the Continental Army and named George Washington its commander. Second Continental Congress. It said the Congress also made plans to raise money and buy supplies for the new army and to seek support from other countries by opening diplomatic relations with them. So they wanted to open up diplomatic relations with other countries. Second Continental Congress named George Washington as the commander. George III denounced the American leaders as rebels and ordered the British military to suppress the disobedience and punish the authors of the treacherous resolve. So I'm not going to get too much into that. But let's get into, let's see. I was trying to see who that was singing. Let's talk about the Declaration of Independence. July 1776, after arduous debate, delegates of the Second Continental Congress voted unanimously in favor of American independence. Thomas Jefferson was selected to coordinate writing the formal announcement, the Declaration of Independence. It listed the complaints the people had against Britain and justification for declaring independence. So they had disputes against Great Britain, so they wanted to draft up the Declaration of Independence. They want to be free from Great Britain and all their demands and problems, so they wanted to be free, so that's why they drew up the Declaration of Independence. It says, this historic work consists of 6 important sections. First, the opening paragraph explains why the Declaration was issued, that is, the compelling necessity for the colonists to break their political ties with Great Britain. They wanted wanted to break their political ties with Great Britain. So that's why one of the main reasons they drew up the Declaration of Independence. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. The second paragraph, the crucial statement of the purposes of government, declares all men to be equal and to have equal claim to life, liberty, and the pursuit of happiness. That was Will Smith said that in one. I think he was in a movie. I forgot the name of the movie. Life, liberty, and the pursuit of happiness. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain and unalienable rights. That among these are life, liberty, and the pursuit of happiness. No government can deny its people these rights. But as you can see, some people over the years, they have problems. They don't believe. They do believe sometimes their rights have been violated. So life, liberty, and the pursuit of happiness. So that means you have a right. You have a right to life, liberty. You have a right to live your life, be free, and pursue whatever you want to pursue to make you happy. I chose to go to college, get my degree. Got married, had a family, so that was my pursuit of happiness. But they say, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these unalienable rights, life, liberty, and the pursuit of happiness. This paragraph also states that government's right to rule is based on the consent of the governed. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive to these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effect their safety and happiness. Third, charges against the British king were reviewed in a long list that enumerated how the king's government had denied the American colonists their rights. So Britain and the king, they were denying the colonists their rights, so they wanted to be free from Britain, Great Britain, and all that mess they had going on. So imagine if we was going through some mess like this right now. It's enough of this coronavirus, but if we were going through some of the stuff that they went through back in the day, I don't know if we could have been, I don't know if we could have made it. So they said charges against the British king were reviewed in a long list that enumerated how the king's government had denied the American colonists their rights, so their rights were being violated. Fourth, the Declaration describes the colonists' attempt to obtain justice and the British lack of response. They wasn't getting justice. Their rights were violated. They were not getting justice as they would see it, And it says, fourth, the Declaration describes the colonists' attempt to attain justice and the British lack of response. Fifth, the last paragraph proclaimed independence. We therefore, the representatives of the United States of America, do in the name and by authority of the good people of these colonies, solemnly publish and declare that these united colonies are and of right ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved. So they wanted to free themselves from Great Britain. Their rights were being violated. And lack of response time when they were trying to get justice. They're trying to get justice taken care of. The king would not move fast enough for them. So, uh, and let's see, final paragraph also. So they just telling you about what was in the Declaration of Independence. The final paragraph also lists actions, the actions the United States of America could take as a country. The last sentence asserts the signers resolve to pledge their lives and everything they own to support the cause of independence, and for the support of this declaration with a firm reliance on the protection of divine providence. We mutually pledge to each other our lives, our fortunes, and our sacred honor. The entire text of the Declaration of Independence is contained in Appendix A. That's probably the back of this. Well, I guess that's in, I don't know what they talk about. They might be talking about, I think they're talking about the back of this book. Okay. Then what did it cost the signers of the Declaration of Independence? I heard they were, I didn't hear it, but I read that they were treated badly, them and their families, they were harassed, and just imagine you trying to, well, I mean, I guess you going against the king, and you writing all this stuff up about all the stuff the king's not doing right. Just imagine, that's just like writing bad stuff about the president, saying this and saying that. You know, sometimes you have to watch what you say because you can, it can be bad for you. So they went against the king and they were saying all this stuff that he's violating their rights and not moving fast enough so they can get justice about, I guess when it comes to certain situations that they were, that they were dealing with. So it says what it cost the signers. The men who signed the Declaration were the elite of their colonies, men of wealth and social standing. They were indeed risking all. They were indeed risking all to sign the Declaration of Independence. It was an act of treason. Imagine that. It was an act of treason for them to try to sign the Declaration of Independence. That's something else, though. I feel bad. I mean, you think about a lot of things that happened in the past between them trying to sign the Declaration of Independence, slavery, the Dred Scott decision about the slave. Remember I read about him? Dred Scott was a slave. So he was a slave, but when he traveled to a free state, he felt that since he traveled to a free state, he was free. But they told him, so he had to go to court. They said, nah, you are a slave. No matter where you travel, you're still a slave. Just because you travel to a free state, that doesn't mean anything. To them, it didn't. But to him, he's like, look, I'm in a free state. I should be free. But okay, so the Declaration of Independence, they were trying to sign that. They drew that up. It was an act of treason for them to try to, sign and draw. I guess put it together, draw it up, sign it. But it was an act of treason. Okay, they said they were risking it all. It was an act of treason, punishable by death. Because it was so dangerous to publicly accuse their king. That's what I'm saying. You accusing the king, you stepping on some serious toes. The names of the signers were kept secret for 6 months. Although most of the 56 signers survived the war and many went on to illustrious careers, including 2 presidents as well as vice presidents, senators, and governors, not all were so fortunate. So some of them went on, but some of them were not so fortunate. Some of their families got killed. And as I read on, it says Jacoby 2000 notes that nine of the 56 signers died during the revolution. 9 of the 56 signers died during the revolution. Uh, never tasting American independence. And there's something. 9 of them died during the Revolution, the Revolutionary War. Never tasting American independence. 5 were captured. 5 were captured by the British. So they said once they signed the Declaration of Independence, 6 months later, 5 of them. They say 5 of them were captured by the British. Yeah, 5 were captured by the British. 18 had their great estates looted or burned. Looted or burned by the British. The British eventually caught up with them. So they signed the Declaration of Independence, and they said that was an act of treason. So eventually the British caught back up with them later on, and some of them didn't make it. Some of them didn't see the light of day. They didn't see no independence. So that's something else. It notes that 9 of the 56 signers died during the Revolution, never tasting American independence. 5 were captured by the British. 18 had their estates looted or burned by the British. Carter Braxton of Virginia and Asheville Crack, who invested heavily in shipping, had most of his ships captured by the British Navy and his estates ruined. So they ruined his estates and burned his ships. So they said he was a Carter Braxton of Virginia, an aristocrat who invested heavily in shipping. He invested in shipping, but the British caught up with him. He had most of his ships captured by the British Navy, and his estates were ruined. He became a pauper. Richard Stockton, a New Jersey Supreme Court judge, was betrayed by his loyalist neighbors, dragged from his bed and in prison, drug him out of his bed and threw him in prison. So that was Richard Stockton. Richard Stockton, a New Jersey Supreme Court judge. New Jersey Supreme Court judge was betrayed by his loyalist neighbors. His neighbors betrayed him. They found him, drug him out of his bed, and threw him in prison. So it says, brutally beaten and starved. Yep, they drug him out of his bed, put him in prison, and starved him to death. His estate was devastated. Although he was released in 1777, his health was ruined and he died within 5 years, leaving his family to live on charity. John Hart, the Speaker of the New Jersey Assembly, was forced to flee in 1776 at the age of 65 from the bedside of his dying wife. So his wife died in bed. He had to flee from her because they were coming. They were coming for him. They said John Hart, the Speaker of the New Jersey Assembly, was forced to flee in 1776 at the age of 65 from the bedside of his dying wife. He hid in forests and caves. He hid in forests and caves while the British destroyed his home. So fields and mills, and ran off his 13 children. And he ran off his 13. He had to leave his wife, and then they said they burned his house down. And wasn't nothing he could do because he probably couldn't get her out of the house. It says when he returned, his wife was dead. When he returned, his wife was dead. His children missing, and his estate destroyed. He never saw his children again and died shattered in 1779. I can imagine. Wow. That's something else, I'll tell you. Indeed, Americans owe much of those 56 signers. I was getting a little choked up about this. Indeed, Americans owe much to those 56 signers of the Declaration. Indeed, Americans owe much of those 56 signers of the Declaration because of their commitment to liberty, the colonists were able to move forward in establishing the foundation for their new free country. Okay. Yeah, so when you think about that, it's something else. Okay, I ran standard sites, and let me see. Let's talk about what we had the First Amendment. We had the First Amendment, freedom of speech, religion, freedom of the press. So in other words, you have a freedom of speech. You can pretty much say anything you want, but you can't threaten nobody. You can't threaten nobody, so that does not come under freedom of speech. So freedom of religion, you can practice any religion you want, and freedom of the press. Freedom of the press, they have freedom. They do have freedom, but they can't. They sometimes they may do it, but they shouldn't. They really not supposed to. In other words, you can't say nothing about somebody knowing that it's not true. So can't say nothing. You shouldn't say, well, you shouldn't, but some people do it anyway. Saying something about somebody that's not true. So you could be faced with slander, defamation of character. You defaming someone's character, saying something about them that you know is not true, it's false. So you have defamation, slander, and libel. Libel is all those spoken words, videotapes, and so slander, defamation of character. So you can't, people do it all the time, but so just wanted to touch base on freedom of the press. That's the First Amendment, freedom of speech, freedom of religion, freedom of the press. Then we have the Second Amendment, the right to bear arms. So you have no quartering of soldiers in the home, but you do have a right to bear arms. But you have to go through a process of background checks and all that. So I never chose to bear any arms, but only these arms right here. So that is the Second Amendment. Let's go to the Fourth Amendment. So the Fourth Amendment. Fourth Amendment. Basically, I was coming up to say that the Fourth Amendment to me would be your privacy rights. So in other words, they might ask you, "Can I search? Can I search you?" And if they have to ask, then you have a right to say, "No, you can't search me. Nope, you cannot search me." So the clauses of the Fourth Amendment. The Fourth Amendment contains two clauses of importance to the issue of search and seizure. The reasonableness clause, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So you can't violate no one's privacy rights. You can't violate the Fourth Amendment. You have a right to be secure in your houses, your persons, your houses, your papers, and your effects. So basically, all your property, your effects, whatever is in your pocket. So in case they say, "Well, can I search you?" Your effects may be in your pocket, your person. That's your part of your person. Anything on your body is part of your person. And your house. No, you can't search my house without a search warrant. You have a search warrant, then what is in the search warrant, it has to be a certain area specified in the search warrant. They can't come in your house if they do search your house. But what's in the search warrant, those are the only areas that they are supposed to search. So it would be unreasonable for them to if they have a search warrant and it only say search the bedroom, the master bedroom, that's the only thing that's in the search warrant, then that would be the only place that they should search. So it would be unreasonable for them to come and search the whole house when there's only one room in the search warrant specified. So for them to get a search warrant, they have to go to the judge. If they feel that they have probable cause and know to say that somebody maybe have somebody have committed a crime or weapons or drugs or somebody, whatever they want, search warrant for. So they would have to go to the judge and swear under oath that they believe that that is what's happening for them to get, a search warrant. That says these two clauses have been viewed. So we have the reasonableness clause and the warrant clause. It says that no warrant shall issue but upon probable cause. If I say that reasonable suspicion that a crime has been committed or somebody's holding drugs or something's going on and some suspicious activity going on that you have probable cause, you have that reasonable suspicion to believe that that is happening. The warrant clause, and no warrant shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that's what I said. Place to be searched. Like I said, you can't have in a search warrant that you're supposed to search one room, but you searching the whole house. That would be unreasonable. That is an unreasonable search. And then you're seizing stuff from the whole house. Seizing, you putting it, taking it back so you can use it as evidence. So reasonableness, how would you define reasonable? It is a challenge, but the cases that have sought to do so have come up with the same descriptions. Most of all would. Reasonable means sensible, rational, and justifiable. So it's reasonable, justifiable. What is reasonable depends upon a variety of considerations and circumstances. It is an elastic term which is of uncertain value in the definition. So let me see, probable cause. So I define probable cause as that probable cause, I guess I would say that would be, it could be a reasonable suspicion, probable cause, a little bit of, in other words, you roll up on, you're a cop and you roll up on somebody driving and you smell, you pull them over for a traffic stop, but you smell, and their window was already down. You walk up to the car and you smell a little weed or whatever. That could be a reasonable suspicion right there, because you'd be like, well, maybe they smoking it in here, I smell it. Maybe they have some more in the car somewhere, That would be, to me, that could get a cop, a reasonable suspicion to believe that maybe some more weed in the car somewhere, But, so it says a probable cause exists when the facts and circumstances within the officer's knowledge and of which they had reasonable, trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. So you have a reasonable suspicion to believe that an offense has been committed. So, suspicion, but you didn't actually, you probably didn't actually, you could have actually saw somebody doing it, because sometimes some things happen. You have off-duty cops, or, some cops, they may roll up on somebody. Sometimes they do see crimes, in action. Okay, here's a case right here. Oh, no, it's not a case. It's a case, but it's just telling you how they define probable cause. United States versus Reamer, D.C., Ohio, 1975. Define probable cause as having more evidence for than against. More evidence for something rather than against it. That's that probable cause. So when you're looking with your eyes, you can see, you say, look, it looks like, crime about to be committed, or they already committed a crime. They looking suspicious, acting suspicious, running down the street. When they see a cop, they running with their hand in their pocket, stuff like that. It says they describe probable cause as having more evidence for than against, more evidence for it than against it. So, or a set of probabilities grounded in the factual and practical considerations that govern the decisions of reasonable and prudent persons, and is more than mere suspicion, but less than the quantum of evidence required for conviction. And Smith versus the United States, they define probable cause as the sum total of layers of information and the synthesis of what the police have heard, what they know, and what they observe as trained officers. We, the court, weigh not individual layers, but the laminated total. This laminated total, more often referred to as the totality of circumstances, or is the principle upon which a number of legal assessments are made, including probable cause. So just you have observational probable cause. Just wanted to touch base on a few terms in this law. This book right here is Constitutional Law and the Criminal Justice System. Constitutional Law and the Criminal Justice System. So, observational probable cause is derived from a government agent's personal experiences. It's derived from a government agent's personal experiences. What officers perceive through their own senses of sight, hearing, smell, touch, and taste. Officers' experience, training, and expertise may lend additional credibility in justifying probable cause. Justifying probable cause is such things sharpen one's situational awareness and enhance the senses, thereby enabling officers to assess things an ordinary person might be unable to. So they assess things different than we do, because we already know that. Because when we stop sometimes, we're like, look, when we are stopped, if we are stopped, we might be like, why in the world did they stop me? But I guess we would definitely have to look at their side. To them, we looking suspicious, but to us, we like, that's something we already do all the time. We do, what we do all the time, the way we drive, the way we walk. But to them, you might look suspicious. The way you walk, the way you had the way you made that turn. You in your car, you made a turn, you made a wrong turn, or, you ran a stop sign. That looks suspicious to them, because they're like, look, really? Because you're like, that was a mistake, that was a mistake. I ran a stop sign, I ran a red light. I know I made a left turn on a red light one time. I made a left turn. I was doing, I think I was driving Uber. I was taking one of my passengers. And I made a left turn on the red light. And I was like, oh, but he didn't stop me though. He just pulled over beside me and said, look, you made a left turn on the red light. I said, I know. But I thought you could make a left turn on the red light. He said, nah. He said, no. He said, no, you can make a right turn on red, not left on red. I said, oh, sorry, excuse me. So he didn't bother me. But I said, thank you, officer. We have informational probable cause established through official or unofficial sources. So informational probable cause, I guess, when somebody's giving them information. In other words, they say you have a neighbor and you think they're selling drugs next door, and you told the cops, or my neighbor, they're selling blah blah blah, or something suspicious going on over there. So they probably would, that is probably what they would consider informational probable cause. Well, that's like third-hand knowledge, because people can say anything when they get mad at you. Well, that's my neighbor. They just jealous of me. They got mad, and they're going to told a lie on me, We have search and arrest warrants. search and arrest warrants of government agents who have probable cause to believe evidence of a crime is located at a specific place, or that an individual is involved in a crime, must go before a neutral and detached magistrate, which is the judge, and swear under oath who or what they are looking for and where they think it could be found. I used to love my law class, business law. I do have my paralegal diploma as well. No knock warrant. We have a no knock warrant, and we have a nightcap warrant. Never heard of this one, but it's a no knock warrant issued when officers want to make an unannounced entrance. When they let you know, hey, we blah blah blah, we at the door, no knock. They do have to identify themselves, let you know that's them, but I guess if they notify, if they let you know that they are at the door and you don't answer, you don't, let them in, that's what they. But I know some states they try to cut out that no knock warrant. Nightcap warrant issued when officers wish to execute a warrant at night. So execute a warrant at night, or sometimes they do it early in the morning, like 7 o'clock in the morning. Catch you when you're sleeping. Catch you when you're sleeping. So stay on your toes, baby. Stay on your toes. Let me see. Let's talk about the law of stop and frisk. The law of stop and frisk is the first point on the continuum of context where police have constitutional authority to interfere with a person's freedom. So when they interfere with your freedom. When you're under arrest, that means they interfere with your freedom. Stop and frisk law, I would make it plural. Stop and frisk laws may be more easily understood by examining its purpose. To balance the rights of an individual and the government's need for tools to carry out its job of protecting society from lawbreakers. Police officers should not be expected to ignore their reasonable suspicions, nor should they be denied the right to ensure their own safety by checking for weapons. The law of stop and frisk balances the rights of the people and the individual during that in-between time where probable cause is not yet developed, but officers should be expected to respond at least in a limited way. It's crucial to understand that any intrusion on a person's freedom involves Fourth Amendment protections, including stops and frisks. So a stop is a brief detention of a person based on specific and articulable facts for the purpose of investigating suspicious activity. No Miranda warning is required. So I want to talk about the Miranda warning next. Let's talk about the Terry stop, and we have the stop and frisk. So that's the Terry stop, Terry versus Ohio. The landmark case. Sometimes you can read up on some of these cases. There should be some online. The landmark case for stop and frisk law is Terry versus Ohio, 1968, which provides a classic example of how a stop and frisk situation may arise and how the law deals with it. In this case, the court addressed the common law enforcement practice of stopping suspects to ask them questions to assess whether they were involved in criminal activity. The Terry decision established that in what is termed a Terry stop, an officer with articulable reasonable suspicion may conduct a brief investigatory stop, including a pat-down for weapons, if the officer has reason to suspect a person is armed and dangerous. So they give a reasonable pat-down if they think that you're armed and dangerous, but they have to have a reasonable suspicion. First of all, the reasonable suspicion that still would be probable cause, because you have to have that probable cause, the reasonable suspicion. That's all part of probable cause. You're not just gonna walk up to nobody and do a Terry stop or stop and frisk unless you have that reasonable suspicion. So It says Detective Martin McFadden had been a police officer with the, this is an example. Detective Martin McFadden had been a police officer with the Cleveland Police Department for 39 years, 35 of which had been as a detective. To untrained eyes, the men detective McFadden saw outside the jury store that they were merely standing there, talking. So so the detective, he spotted some gentlemen, spotted just a few men standing by the store talking. But see, to them, it might look suspicious. But McFadden sensed more. Based on his experience, he suspected they were casing the store, planning to rob it, and possibly were armed. So he saw them standing out the store, outside the store, and they were talking. So he thought that they were probably going to rob the store. See, so he watched as the two men walked back and forth, looking into the store window, walking to the corner, and then returning to talk to each other. So they were walking back and forth, talking to each other. So the officer, he saw them and they looked suspicious to him. So that reasonable suspicion. He saw them walking back and forth. He said they returning to talk to each other. Another man joined them. So they walking back and forth, talking to each other. And the officer, he watching them. They looking suspicious to the officer. Then another man joined them. And then they went inside the store, returned, and the routine continued. When the three men were together outside the store, McFadden approached. He approached them, identified himself as a police officer, asked their names, and grabbed one of the men, placing him between himself and the other two. He quickly patted down the outer clothing of the man, later identified as John Terry. So that's probably why they call it Terry stop, see? So he grabbed the guy, young guy named, his name was Terry, and felt what could be a gun in Terry's pocket, but he couldn't remove it. He ordered the three into the store at gunpoint, removed Terry's coat, and took a 38 caliber revolver from the pocket. When he patted down the other man, he found a revolver in the coat of one. Both were charged with carrying concealed weapons. The defense lawyers argued the guns had been seized illegally. So then they have something also they call fruit of the poisonous tree. So I don't know if that's in this book or not. The defense lawyers argued the guns had been seized illegally, so could not be used as evidence. The Ohio trial judge found both guilty, and Terry and the other man appealed their conviction to the U.S. Supreme Court. So that's the highest court in the land, the Supreme Court. Before this case reached the Supreme Court, the other man died. So the decision refers to only defendant Terry. The legal issue before the court was simply phrased: whether it is always unreasonable for a policeman to seize a person and subject him to a limited search for weapons unless there is probable cause for an arrest. The U.S. Supreme Court upheld the Ohio court verdict, noting Detective McFadden had acted reasonably because his experience and training supported his suspicion that the three men were planning a robbery. So we just assumed they were planning a robbery, but really, see, that's what I was talking about. I mean, a couple times when I first started my video, I talked about mens rea, actus rea. So he didn't actually see them in what I would say, he didn't actually see them in the act. So mens rea, you can be outside a store and you can be thinking about committing a crime, but you haven't actually. You can't arrest me for what I'm thinking about unless I act on it. That's something different. Actus rea. That means you're actually acting on a crime. You committed a crime. Mens rea is like mentally. Mentally you're thinking about committing a crime. So in other words, he saw three gentlemen outside of the store, and they were looking suspicious to him. So he thought they were robbing the store. I mean, it's just a case it's a real case, right? This is a real case. That's why they call it a Terry stop, because one of the gentlemen's name was Terry, and the other two gentlemen, one of them died before they could resolve the case. But I say the issue before the court was simply phrased, whether it is always unreasonable for a policeman to seize a person and subject him to a limited search for weapons unless there is probable cause for an arrest. The U.S. Supreme Court upheld the Ohio court verdict, ruling Detective McFadden had acted reasonably because his experience and training supported his suspicion that the three were planning a robbery. He was suspicious. He felt that they were planning a robbery. The robbery would probably involve weapons, and nothing occurred to make him think differently. He had to act quickly when he saw the three men gather at the store, in their opinion, the court stated. Each case of this sort will, of course, have to be decided on its own facts. We merely hold today that where a police officer observed unusual conduct, which leads him reasonably to conclude, in light of his experience, that criminal activity may be afoot, and that the person with whom he is dealing with may be armed and presently dangerous. Where in the course of investigating this behavior, he identifies himself as a policeman and makes reasonable inquiries. And where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or others' safety, he is entitled for the protection of himself and others in the area to conduct carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. Yes, so officers, they do have to, they do have to follow the rules. We all have to follow the rules and regulations. That's why they have laws, because that is what we are supposed to do. So it says, therefore, such a search is reasonable under the Fourth Amendment, and any weapon seized may properly be introduced in evidence against the person from whom they were seized. Consequences of the Fourth Amendment violations. It says an unlawful search or seizure can have two serious consequences. So if they go and search, say they search your house, and they, like I said previously, they searched the whole house. They searched the whole house, but they weren't supposed to search but one room, because that was in the search warrant. So whatever they have specified in the search warrant, that is the area that's supposed to be searched. So violations of the Fourth Amendment. So we come to the exclusionary rule. So in other words, if they violate the Fourth Amendment, then exclusionary rule allows the evidence will not be admissible in court. So they will not be able to use that evidence. If they get that evidence illegally, if they seize the evidence, if it was an illegal search and seizure, I guess I would say, then we're looking at the exclusionary rule. When police violate a person's constitutional rights by conducting an unlawful stop and frisk or search and seizure, I'm just saying, search and seizure, several consequences may occur. The exclusionary rule may prevent evidence seized in violation of a person's constitutional rights from being admitted into court. Exclusionary rule. So I'm not going to get into too much of this. It's an exclusionary rule among the most controversial and the most passionately debated rules of law governing our criminal justice system. You see how they had to let Bill Cosby out because his rights were violated. His rights were violated. He was not even supposed to be brought up on charges. He was not even supposed to be brought up on charges because the previous I guess I guess I would say in the previous case, he signed the papers and saying that he wouldn't be tried again. But they, I guess it was a new judge, a new case, so they tried him again, which he wasn't even really supposed to be. It wasn't even supposed to be no case. Yeah, so that's how that went down. So then I was talking about the fruit of the poisonous tree. So you have the exclusionary rule, fruit of the poisonous tree. So this is fruit of the poisonous tree. It's Silverthorne Lumber Company versus the United States. Instead of the exclusionary rule, in this case, a U.S. Marshal unlawfully entered and searched the Silverstone Lumber Company's offices and illegally took books and documents. So they went in there illegally, so they illegally seized books and documents. When the company demanded their return, the government did so, but not before making copies of the documents. So they made copies of the documents that they seized illegally from this lumber company. These copies were later impounded by the district court and became the basis for a grand jury indictment. A subpoena was then served on the company to produce the originals. When the company refused, it was convicted. It was convicted of contempt of court. The Supreme Court, however, reversed the conviction, saying they reversed the conviction. The company, they tried to charge the company, but they reversed the decision. The Supreme Court. The essence of a provision forbidding the acquisition of evidence in a certain way is that not merely evidence so acquired shall not be used before the court, but that it shall not be used at all. In other words, once the primary source, the tree, that's why they call it fruit of the poisonous tree, primary source, they call that the tree, is proved to have been obtained unlawfully, and secondary evidence derived from it, the fruit is also inadmissible. So these are some terms that you can go back over. The exclusionary rule, fruit of the poisonous tree, stop and frisk. We had a Terry stop and frisk, fruit of the poisonous tree, exclusionary rule. Read up on the United States Constitution. Now, every state has a constitution of its own. Every state has a constitution of its own. But we have the big body of constitutional law, which is called the Constitution of the United States of America. So that is those in that Constitution, those are the laws that we all must follow. Those are the supreme laws of the land. So I like to read back up on old, back in history, like you know, um, Thomas Jefferson and all the different presidents and all the ones that signed the Declaration of Independence, Constitutional Congress. Read back over that. I like to read back over some of those, because I'm like, they sure went through a whole lot. We think we going through it, but they went through it before we were even born. So I think let's see. Okay, Frisk. Okay, let's talk about the playing field and the playing touch. So these two terms right here these terms are in my business law book, but this is, like I said, this is constitutional. Constitutional law and the criminal justice system. Constitutional law and the criminal justice system. So we have the playing field and the playing view. So in other words, if you ride in your car, officer stop you, and you happen to have a joint on the passenger side seat or top of the dashboard, you have a joint, or you have something that's criminal, a gun or weed or whatever, drugs or whatever, and they just stop you for a traffic stop. They happen to see that. That's definitely going to be part of the plain view doctrine. That's evidence they can use against you in court of law. So I guess you have enough sense not to have it in plain sight. I know I would. Really. if I had something like that. But see, the court ruled in 1993 that police do not need a warrant to seize narcotics detected while frisking the suspect for concealed weapons. So they don't need no search warrant. It says to frisk while frisking the suspect for concealed weapons as long as the narcotics are instantly recognizable. So if they're recognizable, if they can see it, but in other words, if they can't, then they don't have a right to. Then they would probably need a search warrant then. But if they can see it and they know it's there, like I was saying, if they see some drugs on the seat or down on the floor in your car or wherever I mean, even if they're in your house. It said plain feel and plain touch. Of course, unanimous opinion was the first time the court has authorized a warrantless pat-down type frisk to go beyond a protective search for weapons. So I'm not going to get too much into this, but you can read up on some of these cases. It says, this must be a case right here. In Dickerson, the officer exceeded the scope of a lawful Cherry frisk by squeezing, sliding, and manipulating the object to determine whether it was contraband rather than just patting down is authorized by the Cherry stop. So in other words, he's squeezing on the pocket and, making all that which he wasn't supposed to do, because they say that you have to see it and know that it's something illegal. So it says, if the officer, while staying within the narrow limits of a frisk for weapons, feels what he has probable cause to believe is a weapon, contraband or evidence, the officer may expand the search or seize the object. Dickerson emphasized how common law works in creating law. Even though the evidence was held inadmissible in this case, the court created a new plain touch doctrine, which holds the force of law even though Congress never addressed it because the Supreme Court deemed it law. So, excuse me. Also, let's see. Let's see. I'm gonna give you a little bit more apple juice. A little Beyonce in the background. That's a little unsweetened apple juice, but it still tastes pretty good though. Okay, I think that is so plain view evidence. The court recognizes that it would be unreasonable to expect police officers to either ignore or to delay acting on something illegal that they see. Hunsucker, this must be a case. Hunsucker 2003 says it will. Anywhere a law enforcement officer has a right to be, he has a right to see through the use of any of his unaided senses. I guess that's just a book right there. That's just giving you the year that the book, the year and the page. Objects qualify as plain view. So plain view, plain see, plain touch. Objects qualify as plain view evidence if officers are engaged in lawful activity when they find the evidence and it is not hidden. Like I said, if they in a course of business, them conducting business, like I said, just a regular traffic stop, and they see that you have, they happen to look in your window, you got a gun on the floor, or in your car, you have drugs on your seat, passenger seat, a dashboard, or wherever, then they can't act like they don't see it. Excuse me. So that is the plain view evidence. So I call it the plain view doctrine. Plain view, plain touch. So I think that, let me see. And okay, I think let's talk about last two right here. Okay, let's talk about the Miranda Warning. So I learned about the Miranda, how Miranda came about in my business law book. So Miranda was a real case too, just like the Cheryllee stop. So Cheryllee stop was talking about the gentleman, three gentlemen. One name was Cheryllee, and then two other gentlemen, but one died before they could solve their case. So then it's Miranda. This gentleman named Ernesto Miranda, he was stopped, accused of rape. He was stopped, I think this was 1968, I believe. I could be wrong, but I think it was 1968 because it was in my business law book. So he was stopped. He was accused of rape. But what happened was they didn't read him his rights. So his name was Ernesto Miranda. See, that's where they get the name from. Instead, he was accused of rape, but they didn't read him his rights, so that's how that came about. But he took the case. His lawyers took the case, I would say, to the Supreme Court. He won his case, but later on he got in trouble for something else. So let me see what they're saying. Okay, Miranda took the unique step of actually directing police officers to tell individuals they had in custody before questioning them 4 specific warnings. The Miranda warning itself may be read from a credit card or recited from memory and must include the following. You have a right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer now and have him present now or at any time during questioning. If you cannot afford a lawyer, one will be appointed for you without cost. So it says Duckworth versus Egan, 1989, held that the Miranda warning does not need to be given verbatim, word for word, as stated in Miranda versus Arizona. What is required is that suspect's rights, as set forth in the Miranda case, are clearly conveyed. So when a Miranda warning must be given. So then also, if police officers feel that their lives are in danger, by the time they may not have time. They don't have time to read nobody no Miranda rights, Consequences surrounding an interrogation and whether the situation requires a Miranda warning were expanded in Oregon versus Mathiasen, 1977. Sometimes you can read up on these cases. Any interview of one suspect of a crime by a police officer will have coercive aspects to it simply by virtue of the fact that a police officer is part of a law enforcement system. The law enforcement system. When I'm talking through systems, business information system, law enforcement system, county information system, all kind of systems. Every business needs an information system. So law enforcement, they have to bring that information in too so they can do their job. It's like any other business. But you can read up on some of this other stuff, so I'm not going to read all of this. I think one more thing right here, let's talk about, I'm going to read, let's talk about the 4th Amendment, the right of the people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures shall not be violated. So they can't violate your 4th Amendment right by illegally searching and seizing anything in your house. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue upon probable cause. So they have to have probable cause, that reasonable suspicion that a crime has been committed, or evidence linking you to the crime. So they have to have probable cause to know that. Like I said, the other term that I read, what was that? Informational probable cause. So I figured that would be like, in other words, you are your neighbor or something, call police on you and say, well, they've been having wild parties in there. A lot of people keep running in and out their house on a daily basis. I think they're selling drugs over there, so that would be informational probable cause, and you get that information to the police, and then the police sitting outside your house in unmarked cars watching, watching you on a daily basis because your neighbor has been told that, about you that may not even be true. So that would be informational probable cause. So that was the Fourth Amendment. Then the Fifth Amendment, no person shall be held to answer for capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So Fifth Amendment, yeah, so that's I think the double jeopardy laws come under that, self-incrimination, and the other one, due process. So your due process means you are entitled to a, fair trial. It says, except in cases arising in the land or naval forces or in the militia, when the actual service in time of war or public danger, nor shall any person be subject for the same offense. So that's double jeopardy. The double jeopardy laws, you're not subject to the same offense. Not be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself. That's self-incrimination. Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. So that is what they call eminent domain. In other words, if the government wants your property, they have to compensate you for it. That's what it says right here in the Fifth Amendment. It says, nor be deprived of life, liberty, or property without due process of law. Due process means you have to have a fair trial. Nor shall private property be taken for public use without just compensation. So those come under the eminent domain laws. I think that is it for this book. So I think that's it for that book. So like I said, this is a constitutional law and a criminal justice system. So I'm not gonna have this video too long, but that was a good book. That I also had my business law book that I learned. I learned a lot of different law terms. So like I said, you can always read them on. You can always read them. So I have a lot of, I have carpet, but I have plastic runners, and sometimes they just come up and down. But Ernesto, Miranda, you read up on him. So that's where your Miranda rights come from. You have the right to remain silent. Everything you say can and will be used against you in court of law. You don't have an attorney, one will be appointed for you. But I think that's all I had to talk about today. But I want to say thanks for joining me. I am Everything Cheryllee from the Everything Cheryllee brand. You can find me on Instagram, everything_Cheryllee. Check out some of my videos on TikTok. At All Things Cheryllee. At All Things Cheryllee. So that's TikTok, Instagram, YouTube, Everything Cheryllee. But yeah, check out some of my TikTok videos. So I have a nice TikTok game. Let me see if I can find. Let's see if I can find some of my videos. Sometimes you doing your little videos, they take your music off. They take your music off of some songs. So let's see. They took the music off there, but I can't believe that. I didn't mean it when I said I didn't Let's see.
Boy, put your mama on the phone. Pull up on me. Where she at? No. For real. If y'all want to pull up on me, pull up on me. Pull up on me. Where's your mama? Pull up on me. Boy, put your mama on the phone.
Sometimes it has a little glare, but let me see. Monitor. So, I ain't gonna hold this video too long, but just want to say thanks for joining me. Glad you can be here. I'm glad to see you. So I think that was it. Talking about one of the term that another term I learned, and this is probably the last term I'm gonna talk about. We learned about broken windows theory. So basically, broken windows theory is when the theory is that if officers, if you commit a small crime, it's basically saying like that small crimes, if small crimes are committed in the community, officers will try to, I guess I would say law enforcement system, the law enforcement system will try to clear up those small crimes so they won't lead to bigger crimes. So that is the broken windows theory. In other words, officers behind you, you run a stop sign, to them, that's probably a crime. When they stop you, they try to clear it up because they figure, oh, she ran or he ran a stop sign. They may be apt to commit another crime. Well, I mean, that's why when you see some people have, been charged. When you have just, a few little crumbs of marijuana or something like that. If you're caught and if you're caught with marijuana and you just had a little bit, but laws have changed now, but so they figure on, and you can just have a couple of crumbs and you still probably have to go to court if they caught you. If they catch up to you, you got a little bit of crumbs, they figure, that's a small crime to them, but that might lead to a bigger crime. So that's what under the broken windows theory, that's what that is. So in other words, in a lot of these high crime areas where they have crack houses and houses, windows boarded up, sometimes people may go in there. You go in there, they're still breaking and entering because that's not your place. So that's what that is, broken windows theory. Trying to clear up all the small crimes in these low-income communities. That way it won't lead to larger crimes. So, but I think I'm going to end this video for now. I want to say thanks for joining me. Hope to see you on my next video. And you all have a good one.